He did not argue. He did not object. He did not posture for the cameras or turn toward the gallery with defiance. When the judge finished speaking, when the court formally confirmed that the subpoena would stand, Donald Trump simply froze. For a brief moment, he didn't move at all. His attorney leaned closer, whispering something too low for microphones to capture. The exchange lasted only seconds. No visible reaction, no reply anyone could see. Then slowly, almost mechanically, Trump's shoulders sank. Not in anger, not in protest, but in something closer to surrender. He lowered himself into the chair as though gravity had suddenly doubled. Both hands came up to his face, his elbows rested on his knees, and then his body began to shake. Not theatrically, not performatively, just shaking. Small, involuntary tremors, the kind that happen when adrenaline drains too fast. The courtroom noticed immediately. The sound inside the chamber changed. Papers stopped moving. Chairs stopped creaking. Even the quiet background murmur from spectators disappeared. No one spoke, because this wasn't what they expected. This wasn't a verdict. It wasn't sentencing. It wasn't even a ruling on guilt. It was procedural, routine technically. And yet everyone in the room understood something had shifted. Because sometimes, in criminal litigation, procedure carries more weight than punishment. Federal prosecutors under Special Counsel Jack Smith have been investigating allegations of obstruction of justice connected to classified materials recovered from Mar-a-Lago. According to charging documents and prior court filings, the government alleges that Trump retained documents marked classified after leaving office. They allege he was formally requested to return them. They allege he did not fully comply with a federal subpoena demanding their return. And they further contend that certain records were concealed from investigators. The defense disputes all of it. They argue misunderstandings, overreach, authority questions, classification disputes. Those arguments remain active. Nothing has been decided. But the issue that triggered this morning's moment had little to do with the documents themselves. It wasn't about boxes. It wasn't about storage rooms. It wasn't about surveillance footage. It was about something far harder to measure: intent, because possession alone isn't enough. Prosecutors must prove knowledge. They must establish that Trump understood the materials were classified, understood his legal obligations, and acted deliberately. That mental state, that awareness, is what transforms paperwork into potential criminal liability, and that is where the subpoena enters. According to representations made in court, prosecutors believe that Barron Trump may hold relevant information about conversations that occurred inside the residence. Not legal advice, not privileged communications, but observations, moments, statements overheard, discussions that might speak to state of mind. The government argues he was present during periods when attorneys met with Trump, when document storage locations were discussed, when federal inquiries intensified, when tensions inside the home reportedly grew. They assert that he may have overheard statements reflecting awareness, or lack thereof, about the nature of the materials. Under federal law, there is no blanket parent-child testimonial privilege. There is no automatic shield. If a witness is believed to possess material information, a subpoena may be issued. Barron Trump is 18, legally an adult, subject to compulsory process like any other citizen. Trump's attorneys immediately filed emergency objections. They argued irreparable personal harm. They argued speculative relevance. They argued proportionality. They argued that forcing a son to testify against his father crossed a line that should not be crossed. But emotional harm is not a legal standard. Evidence is. The judge reviewed the government's proffer, a summary of the anticipated testimony, and ruled the subpoena valid, properly issued, and enforceable. The deposition would proceed. That confirmation is what triggered the visible reaction. From a procedural standpoint, the ruling was straightforward. A deposition allows prosecutors to question a witness under oath. Every word is recorded, every answer preserved. False statements expose the witness to perjury liability. If testimony is deemed material, portions may later be introduced at trial. Routine, common, technically unremarkable, but strategically, potentially explosive. Because this changes the case from objects to people, from documents to memory, from evidence to emotion. If Barron testifies that conversations occurred indicating awareness of classification status, prosecutors could argue that supports intent. If he describes discussions about withholding materials, they could frame that as obstruction. If he remembers nothing substantive, the deposition might produce little benefit at all. Right now, no one outside sealed filings knows what prosecutors expect him to say. That uncertainty is destabilizing. Trump cannot discuss substance with him. Any attempt to shape or influence testimony risks allegations of witness tampering. Even casual conversations become dangerous. Every word becomes a potential liability. The defense must tread carefully. The prosecution will watch closely. And that legal pressure, that narrowing corridor of permissible action, can weigh heavily. Observers noted something else. Trump has faced indictments before. Multiple times, he has attacked prosecutors publicly, mocked investigations, projected confidence, sometimes even defiance. But this looked different. Not angry, not combative, just quiet. The court recessed briefly after noticing his condition. U.S. Marshals approached. Medical assistance was offered, declined. When proceedings resumed, he remained seated, still, reserved, contained. Why would a procedural ruling trigger that kind of reaction? Because it represents loss of control. A federal judge has ordered that someone inside his immediate family provide sworn testimony in a criminal investigation. Not a staff member, not a lawyer, family. The legal system does not carve out emotional exceptions. It measures evidentiary value. And when relevance is established, the process moves forward, indifferent, impersonal, unyielding. Defense counsel will likely continue filing motions. They may seek protective orders. They may attempt to limit scope. They may challenge specific lines of questioning as irrelevant or harassing. But the subpoena itself has already been affirmed. The deposition is scheduled. If Barron complies, he will enter a conference room with federal prosecutors, defense attorneys, and a court reporter. He will raise his right hand. He will swear to tell the truth, and questions will begin. Trump will not be present. He will wait for a transcript, a document that could either stabilize his defense or intensify the government's leverage. Prosecutors already rely on physical evidence, recovered documents, surveillance footage, employee testimony. Those pieces address conduct. But intent remains central. Intent is invisible. It must be inferred, often from words, sometimes from those closest to the accused. Family witnesses introduce a unique dynamic. Jurors tend to view them as reluctant. If they speak candidly, their credibility can carry unusual weight. If they appear evasive, the damage can cut both ways. Either outcome introduces unpredictability, and unpredictability is the enemy of legal strategy. Defense attorneys prefer known risks, known testimony, known evidence. A family deposition is neither. Attorney-client privilege still applies. Protected legal advice cannot be compelled. But casual conversations are not privileged simply because they happen inside a home. Statements about possession, about compliance, about refusal, those may be admissible. Another layer involves immunity. Prosecutors sometimes offer limited immunity to ensure truthful testimony without fear of self-incrimination. There has been no public indication that such protection is being considered. Still, it remains an available tool, another variable, another unknown. If testimony favors the defense, they may want it introduced. If harmful, they will fight admissibility. Motions will follow. Arguments will be made. But once words enter the record, they cannot be erased. That is the weight of a deposition. Words become transcript lines. Transcript lines become exhibits. Exhibits become arguments. The law treats this clinically, almost coldly, truth-seeking above all else. Even when families are involved, even when the personal cost is obvious. Spouses have limited privileges, adult children do not. That is the framework. That is why the judge ruled the way he did. And that is why emotional appeals fell short. Public reaction has already polarized. Supporters call it excessive, critics call it routine. Legally, it is neither symbolic nor retaliatory. It is simply a tool, authorized by rule, used when prosecutors believe information matters. Whether it becomes decisive depends entirely on what is said under oath. Nothing more, nothing less. Trump remains presumed innocent. Allegations remain allegations. A subpoena is not proof. A deposition is not guilt. The burden still rests entirely on prosecutors. But burdens feel abstract compared to consequences, because consequences are human. Next week, a young adult will answer questions about conversations inside his own home, about his own father, under oath. For Trump, the reaction this morning may have reflected recognition that litigation has moved inward, from public battles to private spaces, from strategy to exposure. Control narrows as process expands. The legal system continues step by step, methodical, unemotional, indifferent to status or surname. And when the next step occurs, it will happen the same way every other step does, quietly, under oath, on the record, permanent, because once testimony enters the record, it never leaves.